that required you to then interview Officer Vasquez as to what he perceived, what he saw, based on his role in the reenactment?
Correct.
Now, yesterday, literally at the 11th hour, we were provided two, I guess, grids, for lack of a better word, of a few of the streets of downtown DeLand from the Community Services Director that purports to have a measurement from the center of the street and how many feet it would be. And I believe the gentleman's name, I'll get it here for you. Got it right here. Mr. Werbiscus, Werbiskis. Do you know that gentleman?
I do not.
And I know you were, the rule of sequestration was invoked, so I presume you didn't hear his testimony. Is that correct?
No, correct.
Now, Mr. Werbiscus was literally tasked yesterday for the first time to doing two things: providing printing to downtown maps, and then testifying in this room with little to no notice. And he stated that he produced these within about 10 minutes. Would you have any reason to dispute the testimony of Mr. Werbiscus?
No.
And on this, he claims to have some methodology, or the system does, that can measure from the midpoint of a street to the next block and the next block, just by hitting some buttons. Are you aware of that?
Aware of his capability of doing that?
Yes, sir. Of creating a kind of map that could give you measurements.
I have no knowledge of who this person is, so I couldn't tell you that.
And the truth is, when you were doing your investigation, you never reached out to anyone to assist with doing a reenactment, did you?
Correct.
You never reached out to any of the departments here in the city, such as the Community Development Director, who utilized the Volusia County Appraiser's records, he said, to create Cities Exhibits 17 and 18.
I did not.
All you did was 6 months after this incident, go out there with part-time Officer Vasquez, and the two of you claimed to do some sort of a reenactment, correct?
Correct.
Of which there's no record to support other than you verbally telling this officer in his second interview.
Correct.
And you would have the arbitrator and all of us believe, first of all, that you even did a reenactment, correct? You want us to believe that.
Absolutely.
And why should we? There's no record evidence of it. We have evidence of all the other things you did.
It's documented. I wrote it in my report saying that I did a reenactment, and we can go back out to the scene if you like. And we can take the same measurements from the place where I was at, and it'll give you the same readings that I have on my report.
No, we're here in the trial. You had an opportunity to provide that information, didn't you?
I wrote it on my report.
It's in the transcript. Where's it written? Oh, it's in your report. The report, the one that they entered into evidence yesterday, are you aware it's not even signed by you?
I have the one that signed. I have the one that signed.
And we're going to get to that in a minute, too, about how you didn't follow both parts of the Florida statute.
Objection. Counsel's testifying now.
I'll withdraw. Lieutenant, this was a sloppy investigation, wasn't it?
No, it was not.
Just like the Malera one was, wasn't it?
What does Malero have to do with this case here?
It showed your incompetence,
Oh.
and we're getting it
Yes,
in.
your opinion.
Argument.
Hang on.
I'll withdraw. You did one IA with no training. That was Malera, correct?
Correct.
We're now to another one that I'm here for, and we're seeing that you did a reenactment, you claim, with no evidence to support it, other than you writing those words in your report, correct?
Correct.
You certainly supply any other documents that you deem necessary to support the allegations, inclusive of looking at the CAD records, the charging affidavit, and any other records you need, correct?
Correct.
But the one thing that could help this case and help the city to support your recommendations as the person who started this IA, that would be the reenactment and the measurements to support that. There's no documentary evidence for it.
No, sir.
One thing I didn't ask you on the reenactment, why the heck did you wait so long? Why'd you wait 6 months?
So, if you look at the report, it took me a while for me to actually do the deep synopsis to the entire investigation. When that was brought up to me, obviously I had to go back into looking into how I can actually go about clarifying whether Mr. Goins was able to see what he claimed he saw that night. So it took me that long.
And I'm gonna make an observation here, and you saw me have to put mine on and off several times. I'm getting older too. I'm almost 60 and I pop these on more than I used to like to. But you told us here yesterday that there's no way that this officer could see what he saw, correct?
Correct.
And I'm looking at you right now and you've been wearing glasses from yesterday and throughout today.
The reader glasses.
Well, that means your eyes aren't exactly the best, correct?
And I just started wearing glasses. I wasn't wearing glasses at the time that I actually conducted my investigation.
You ever been designated a sniper or a marksman able to hit something at 700 yards?
I've never applied for that.
Do you think you could do it?
Not now with the glasses, obviously. Well, maybe. I mean, we can use the scope.
Could you do it in 2019?
Yes.
June 2019.
Yes.
So throughout this proceeding, you're wearing glasses, and you're telling us you're questioning the eyesight of a man who was a marksman for the DOC.
That's
Correct.
a marksman. You don't take a shot unless you have some kind of scope, high power scope. They're not going to put somebody in a position where you're a sniper and not give them a scope.
You've never done that role, have you?
I have not. No, I have not.
So you're now testifying on something you have no knowledge of.
But I have plenty of officer friends that are actually in the SWAT team that are actually, we've discussed this over and over. As a matter of fact, I actually attempted to become a SWAT man.
Okay, so what you're telling me right now is hearsay, what people have told you, correct?
Yes, sir.
Okay. Now, and one other question about Officer Vasquez, who you said assisted you. And he's got his hands on this IA too. We're going to get to that, some memos back and forth or emails. I keep wanting to call him Sergeant, but Officer Vasquez was sworn law enforcement, correct?
Yes, sir.
And under the Officer's Bill of Rights, are you aware that it says all law enforcement shall be sworn who testify?
He is a sworn officer.
Okay. Well, let's turn to Exhibit 6. And maybe this will help clear that up. Okay, tell me when you're at tab 6, sir.
I'm here.
Okay, so now we know that you wrote the memo that you titled Citizen Complaint February 5th. That same day, it looks like from you sent this document to Officer Goins, correct?
Yes, sir.
So you were pretty busy that day, February 5th, correct?
Yes, sir.
You decided to initiate an IA, write a memo to the chief, get him sign it back, and now kick out an internal investigation notice to Officer Goins, correct?
Yes, sir.
And this is all within a week of receiving what was no more than a preservation of evidence letter and a request for records.
Yes, sir.
Okay. So make sure we're clear. And you started off with 3 perceived violations, correct?
Yes, sir.
Now, since you're the one under oath that you've told us started the IA, are you the one that came up with these 3 possible violations?
Yes, sir.
So solely on you, not on Deputy Chief Patton, former Deputy Chief Patton, correct? no, I'm trying to make sure I'm clear for the record. You're the one that came up with these three allegations. Solely you.
Yes, sir.
Okay. Now, this, if you look on page 2, you see that Officer Goins signed off on it, correct?
Yes, sir.
Now, it has 5/7/19. Do you know why?
I'm sorry.
Looks like 5/7/19 on the next page.
That's probably the day I handed it over to Mr. Goins. I'm not 100% sure.
Okay. So, and I'm glad to clear, because this is the first time I've had a chance again to talk to you about this. I noticed that seems, to the reader it looks odd. It's dated February 5th, but then it's signed for on May 7th. Is that because you initiated the IA, but you didn't question him until other witnesses had been questioned?
Correct.
So, even though it's dated February 5th, you didn't give this to him until May 7th, correct?
To May 7th.
Yeah, turn to page 2 again. Has Goins signing it on May 7th.
I don't know why that would be.
In other words, you left this date. Here's what I'm going to get at. And you're going to see other documents. I think it's going to become more clear to you. You left this date of February 5th at the top of the NOI on several documents, didn't you?
Probably so.
Okay. So, May 7th is when Officer Goins receives notice on the verge of you questioning him, correct? Or shortly.
I'm not 100% sure why it says 5/7. I wouldn't have waited 3 months to actually serve him
Okay.
the paper.
Now, if you turn to the next page, and it has DPD, this is section 112.532 of the Officer Bill of Rights, correct?
Yes, sir.
All right. And is this something that is provided to the officers who are going to be questioned?
It is.
Just want to call your attention briefly to subparagraph D, second sentence, all identifiable witnesses shall be interviewed. You see that
I do.
whenever possible?
Yes, sir.
Again, you didn't interview Mr. Staff, you told us, correct?
Correct.
You did interview Officer Vasquez, correct?
That's correct.
All right. Now, I have some question about this, because if you'll leave your finger here and turn to tab 36, you need to take this one maybe out of the binder since it's smaller, or you can leave your hand there and turn to tab 36.
Okay.
It appears that what this department provides to its officers is not the complete section 112.532 of the Officer Bill of Rights. Do you have any reason to dispute that?
No.
Okay. And specifically under subparagraph 2A, there is reference to okay. Would you agree that it's titled under tab 6, Police Officers Bill of Rights, Florida Statute 112.532, but this isn't all of the Officer Bill of Rights. Would you agree with that?
Which one are we talking about here?
The one in tab 6.
Oh, yes.
That there are other provisions to the Officer's Bill of Rights than just this section. Would you agree with that?
There's subsections, yes, sir.
Okay. Now, if you now turn to tab 37, for example, here is 112.533 that we're going to talk about in a little while. This has to do with the receipt and processing of a complaint and a charge, correct?
Yes.
We don't see that being provided to the officer in the packet that you provide to them, correct?
There's a mention to it on, let's see, this subsection, the section B, where it says notwithstanding 112.133.
Where are you referring that to, sir?
Tab 6,
Okay, and what page?
second page down to the last paragraph.
Yes, sir, is notwithstanding whenever law enforcement officer is subject to disciplinary action? Is that what you're referring to, sir?
Yes, sir.
Okay. But what is provided to the officer is not the, it certainly doesn't include 112.533, correct?
It's not on here, it just mentions it. Yes, sir.
In fact, now on 36 again, the provision you just pointed us to behind tab 6, that's in the actual statute. You'll turn to page 2 behind tab 36. You see 4B, notwithstanding.
Yes, sir.
So that provision is, that's all just a part of 532 is what I'm getting at. So my question to you, sir, is would you agree that when you give a notice of investigation to an officer, what's on DeLand Police Department letterhead, you only give them 532,
Yes.
okay? And would you agree that 533 behind tab 37, that addresses the obligations in part of someone like you as the investigator, as to verifying the contents of being true and accurate and swearing under penalty of perjury. You see that, sir?
Yes, sir.
This department doesn't give the officer that notice, do they?
Notice of the 112.533.
Yes, sir. It doesn't give them that.
It's
does it?
not on the one, correct?
And it also doesn't give, if you'll turn behind tab 37, the very next one, it doesn't provide the officer with the failure to comply in official misconduct statute, which is 112.534, does it?
It does not.
So the department here only gives an officer a piece of, or a portion of, the Officer Bill of Rights when it puts them on notice, correct?
Yes, sir.
And you are in charge of the IA department now, correct?
I am.
Do you think you are affording the officers of this agency due process by only giving them a portion of their, let me finish, by only giving them a portion of their rights by law?
So in the training part that I actually took in reference to the certificate that I received, it never mentioned us having to go beyond what we already had in our agency. And looking at past practices, it's always been the same document that we've actually presented to the officer when we're doing the investigation.
At this time, Mr. Finnegan, I'd like, if I haven't already moved in Union's Exhibit 6, I'd like to do so.
Which one was 6?
It was the notice of investigation, the Garrity, the Officer Bill of Rights, at least 112.532.
No objection.
Union Exhibit 6 is admitted in evidence as Exhibit 6.
And also, Mr. Finnegan, I'd like to move into evidence Union's Exhibits 36, 37, and 38, which are 112.532, 112.533, and 112.534 of the Law Enforcement Officer Bill of Rights.
I do have one objection there. This looks like a 2021 copy, and each of those documents show that there were, or the first two documents show that there were revisions in 2020. So I don't know if this is the version that was applicable in 2019. So I don't generally have an objection to them being introduced, but I'd like it noted that these are current versions of the statute, and there have been revisions since this internal affairs investigation.
I have no, with that understanding, I'm not aware of any substantive changes to the provisions we're going to talk about, but if we need to update it with the version that was in effect at that time, I can do that.
Okay, so
I can provide those to you.
there's
And
no objection to 36, 37, 38 as they're in the notebook coming into evidence as Union Exhibit with Mr. DeRozier's comment about these being 2021 versions of the statute
see.
But if not, there, what's in the notebook
Okay.
is accepted into evidence as Union Exhibit 36, 37, and 38.
And if I may, I can supply those if I can't get them today, early next week. That'd be all right?
Even-
By early next week.
I mean, the law is the law, so, I mean, if there were substantive changes, I'm sure we'll highlight them in the briefs, so that's fine with me.
Okay. And, Mr. Finnegan, did we admit into evidence the certificate of training for Lieutenant Milan, which was 35?
Yes.
Okay, thank you. Just to make sure. Okay, Lieutenant Milan, continuing on with this now notice that you gave him behind tab 6. I'm going to turn now to I guess it'd be the 5th page. It's still part of the statute. Should have subparagraph 5 at the top, retaliation for exercising rights.
Yes, sir.
Okay. First of all, do you notice at the bottom of the page, it's got, again, appears to be Officer Goins' signature with a 5, either 7 or 17, 19.
Yes, sir.
Okay. And then if you turn the next page, you see Officer Goins signing the Garrity notice, Garrity warning on 5, 7, and 19, correct?
Yes, sir.
All right. Now, did you understand from your training and from the Officer Bill of Rights that by Florida law, you see it under subparagraph 6 here on this page, that an investigation has to be completed within 180 days unless it meets one of these exceptions that's listed here?
Correct.
And then at the end of paragraph 6, before it goes into the exceptions, do you see where it reads, notice to the officer must be provided within 180 days after the date the agency received notice?
Oh, where's that? I'm sorry. Yes, I see that.
Okay. And you believe you completed the investigation within 180 days?
Yes, sir.
Okay. Now, part of the completion of it, though, is following what the law requires, correct?
Correct.
Now, you told us, you told us that you have a signed version of the IA, is that correct?
Correct.
And I think it was City's Exhibit. City's Exhibit 5. It's dated July 11, 2019. You see that, sir?
Yes, sir.
From you to former Deputy Chief Batten, correct?
Yes, sir.
And on the last page, page 21 of City Exhibit 5,
Yes, sir.
you have the signed version of this, correct?
Yes, sir.
Other than having the signed version, do you believe that the report that the city entered into evidence as Exhibit 5, dated July 11, 2019, do you believe that to be the final version of your report?
Yes, sir.
And if you look at page 21, your signature line there, sir,
Yes, sir.
you have part of the required statute, correct?
Yes, sir.
You don't have both provisions as required by 112.533 Florida statutes, correct?
Yes, sir.
And it turned out, while you're open to that page of your report, if you'll go now to tab 37 in the white notebook. You should be looking at 112.533. You see that, sir?
I do.
So when you submitted this report, I know we're looking at an unsigned version, maybe on a break we can get the signature page substituted, but you told us under oath, you know you signed the one dated July 11th, correct?
Yes, sir.
And when you sign an IA report, you're done with it, right? That's your verification that you are complete. It's over, correct?
Yes, sir.
And isn't it true that at that moment, from that moment forward, it actually becomes a matter of public record because the investigation is closed?
It's not close till the officer has the show cause.
Okay. Once the show cause, then it was closed. And we had a show cause hearing in this case, correct?
Correct.
You told us yesterday you were present at it but didn't say anything. I guess maybe you weren't asked anything. Is that correct? Okay. So the show cause hearing would have occurred sometime, I believe he got his termination letter from the chief, a recommendation letter from the chief of July 22nd. So do you recall the show cause hearing being sometime in late July, early August?
Yes, sir.
We're now well over 2 years after that date of his show cause hearing, correct?
Yes, sir.
Now, in the statute we're looking at here behind tab 37, would you agree in the last sentence of that first full paragraph of 1A, it says when law enforcement or correctional agency personnel assign the responsibility of investigating the complaint, prepare an investigative report or summary, regardless of form, the person preparing the report shall, at the time the report is completed, do these two things. Do you see that, sir?
Yes, sir.
And it has 1 and 2.
Yes, sir.
Your report was completed, correct?
Yes.
It was completed as of July 11, 2019, correct?
Yes, sir.
You did not fulfill number 1 by law, correct?
It was not on my report, correct.
And even as we sit here, December 14, 2021, that report has never been properly completed according to 112.533, has it?
Objection, that calls for a legal conclusion, it's not a lawyer.
I'm not asking for a legal conclusion. I'm asking if he included language in the statute.
Overruled.
The report that you submitted, and you said you actually have the signed version of, and there's no changes to it, has that same, I, the undersigned, do hereby swear that to the best of my knowledge, I have not knowingly deprived the officer of his rights, correct?
I have that verbiage on that report, if you look at the report themselves.
But you did not ever verify the contents of the report as being true or accurate based on your personal knowledge, information, and belief, correct? In fact, yesterday under oath, December 13, 2021, was the first time in response to a question to Mr. DeRozier that you said that you stood by what was in the report, correct?
I do.
So that's the first time we've had you under oath swear to the report as being true and accurate was in this very City Hall Council room on December 13, 2021, correct?
Yes, sir.
That's well more than 180 days past the commencement of this investigation, isn't it?
It is.
And drop down 2 paragraphs under 112.533. Would you agree that this reads, the requirements of subparagraphs 1 and 2 shall be completed prior to the determination as to whether to proceed with disciplinary action or to file disciplinary charges? Do you see that
I
sentence?
see that, yes, sir.
And you were trained on the Law Enforcement Officer Bill of Rights.
Understand that this is past practice. At the time, all past investigations did not have that verbiage. To include when I actually went to the course themselves, they never stated for us to add that verbiage into our documents.
So this department's been violating the law for a while, is what you're saying.
Objection, argumentative.
Is that your, that's what I understood you just, they didn't include this one?
Hang on, there's an objection.
Okay. I'll rephrase it. So am I correct, you're saying that this department wasn't including the verification of the report being true and accurate for some time.
On the reports that I've actually looked at, it didn't have that verbiage on there.
But you could see in plain writing, the King's English, that it's called for, right?
I understand that, but it also says, I undersign, do hereby swear under penalty of perjury. And that's what I have on there, basically saying that I do swear.
No,
to the
no,
fact-
sir. You do not. Look at City Exhibit 5 again, page 21. You do not say anywhere above your signature line, do you, that the contents of the report are true and accurate based upon your personal knowledge, information, and belief, do you?
It says on my report, I do undersign, do hereby swear under the penalty of perjury that to the best of my personal knowledge, information, and belief, I have not knowingly or willfully deprived or allowed another to deprive the subject of the investigation of any of the rights contained, and it tells you the specifics.
Right. You captured part 2 of 112.533,
Yes, sir.
correct?
Yes, sir.
But you skipped part 1, correct?
Yes, sir.
And the statute says the requirements of subparagraphs 1 and 2 shall be completed, doesn't it?
Yes, sir.
Prior to the determination as to whether to proceed with discipline, correct?
Yes, sir.
This was sent on, and the deputy chief and the chief proceeded with discipline without the requirement of the law, correct?
Yes, sir.
And the reason I know that you now know better than that, officer, is we're going to look at one where you did sign last year. If you'll turn now to tab 33. This is an IA that you also did for an Officer Krashenko, for the court reporter, Krysschenko. You recall doing an IA report, completing it, submitting it to Chief Umberger last year, 2020.
Yes, sir.
Is this a copy of your IA report?
It is.
Now, I will submit to you, it's not the entire report because this notebook was already big enough. I've given you the relevant portions. I've given you page 1, and then the allegations, areas of concern, and then on the last page, if you would look, sir, of page 34, I'm sorry, tab 33. And what do you see under recommended finding for review? Do you see what you, how you laid that out, sir?
I have.
Looks far different when we keep the tab open to City Exhibit 5 in your IA report in this case.
Correct.
Do you agree?
Yes, sir.
Not only do you have that you've read the foregoing document and swear it to being true to the best of your knowledge and belief, you included both provisions of the statute as required by law, correct?
Yes, sir.
You actually even had it notarized, didn't you?
I did.
And this was done over, looks like, in January of this year, correct? January 5th? Talking about the Krashenko one.
Yes, sir.
So basically 11 months ago, at least as of 11 months ago, you were doing it the right way, correct?
Yes, sir.
But you and the city, not solely you, but the city has still advanced this case to arbitration and made no effort to go back and correct the IA report for Officer Goins by law, correct?
Correct.
And isn't it true, because if the city did so, they would know they had no basis and where it was illegal to impose discipline before both parts of the statute were met as required by law?
Now he's calling for a legal conclusion.
No, I'm just having them read the statute. The statute says,
Gentlemen,
all right,
an
I'll
objection to your question.
it is not calling for a legal conclusion. It's calling for following the plain language of the statute.
Okay, so what do you want this officer to
I want this officer, would you agree, officer, the city can't now correct it because it would be an acknowledgement that it violated the statute, because discipline's already been issued.
Objection, that calls for multiple conclusions. It's asking if an acknowledgement by the city
I'll
somehow
rephrase it.
means something else.
I'll rephrase it.
He's going to rephrase his question again.
Have you ever been asked to go back and correct your recommended findings in this IA report for Officer Goins, dated July 11,
No.
2019. Do you realize if you did make it like Krashenko's, which is by the statute, that it would illustrate that discipline has already been issued in the case of Officer Goins? He's already been terminated, correct?
Correct.
But you acknowledge that at least in the case of Officer Goins, you did not follow 112.533.
Correct.
And your chief, who's sitting right over there, less than 10 feet away from you, has taken no disciplinary action against you for violating this officer's rights, correct?
So I'll go back to the training that I had. At the time that I went to take that course, they never mentioned anything about this language into our final report.
Isn't one of the fundamental tenets that we all hear, I heard as a kid growing up, ignorance of the law is no defense?
You can say that.
Haven't you heard that?
I have.
Doesn't this department have a policy that says there's no excuse for not knowing the law?
There is.
And you're tasked with a position where you have fundamental impact over someone's livelihood and career. Would you agree with that?
Yes, sir.
And you're telling us you didn't know that the law required what you now understand it requires, correct?
Correct.
So at the time you made a decision impacting his career, you're telling us you didn't know the law.
Well, I didn't make a decision in his career. I actually conducted the investigation. I had no decision as to whether what disciplinary was going to be taken on that officer.
But would you agree if you had never wrote that first memo initiating the IA, we wouldn't be here today?
I agree.
So you started the process.
Absolutely.
But you're wanting to now tell us in the same breath, but I didn't have any role in his termination. Is that what you're telling us?
That's correct.
So you want it both ways. You started the process, but you don't want any responsibility for your actions?
Nobody said that I don't want to take responsibility for my actions. I actually did the report to the best of my knowledge.
And you screwed it up,
Objection.
correct?
Hang on, there's an objection.
Okay.
Question is, and you screwed it up, correct, what's your response to his objection?
This is cross-examination. I don't think it's an improper question.
Overruled, I'll let him answer.
You screwed this one up, didn't you?
I didn't put the language at the end, yes. I did not put that on there, but I didn't screw up the report itself.
Is it not closing it out properly by law, by statute, messing it up?
Objection.
Hang on. An objection.
It's a legal conclusion again.
You are a law enforcement, he's a law enforcement officer.
Hang on.
Okay.
There's an objection to your question.
It is not calling for a legal conclusion. He's a 19-year law enforcement officer, trained on the Officer Bill of Rights, conducting IAs. I think he can answer this question.
And
If I
can
could
read back on the question.
Question, is it not closing it out properly by law, by statute, messing it up?
I think, Mr. Wilson, you are asking him a legal conclusion with the
Okay.
question I just heard. Isn't it by law, by statute, not closing out correctly, screwing up the report?
Okay. I'll withdraw the question. This IA, as we still sit here today, December 14, 2021, has still not been closed out properly. Is that correct?
Objection. That's still, if I could just elaborate, maybe we can get on this, but
I'll
whether or
withdraw
not
the
something is
question.
properly closed out isn't.
Hang on. He's
I'll withdraw the
withdrawing
question. This IA that you did and submitted to the city as your final report still has not had both provisions of the statute included, correct? And do you have some understanding now, based on your 19 years and being an IA investigator and your training on the Law Enforcement Officer Bill of Rights, what that means?
Yes, sir.
And what does that mean?
Basically, it states that I'm supposed to have that at the end of my report and investigation.
And does the statute also say that you agree that it says that no discipline should have been issued until both parts had been completed?
The wording is there, yes.
All right, we'll move on to something else. Do you want to take a short break, Mr. Finnegan?
Well, it's 10:30.
I'm transitioning, I thought this might be a good time, so.
Okay, why don't we take that a 10-minute break, come back at 10:40?
Thank you.
Is that enough?